Oh, hey folks, elder law care attorney Patrick Kelleher coming to you from elderlawcare.com. Elder Law Care Warriors, thanks for joining us here today. We're going to get right down to business here because one of our subscribers sent in an email, very important email, very serious subject matter. Hey Patrick, how do we protect our elders from financial abuse? What they refer to as financial exploitation on seniors. How to spot it and how to prevent it. Folks, pull up your chair, get your pen out and your notebook because I'm going to teach you how to slay that metaphorical financial beast. That's a third-headed monster, potential financial creditors and predators. This would be a financial predator. And folks, sometimes it's a wolf in sheep's clothing. What do I mean by that? What do you think I mean by that? Wolf in sheep's clothing, folks. Meet with a lot of our clients, met with clients recently, no names of course. They sadly reported to me that their elderly parent was being taken advantage of by another family member, one of the children. I'm not going to get into so much details, but long and short of it, since the pandemic, one of the children kind of started to help the elderly parent who was having medical issues and then kind of help themselves to some additional extra servings of the parent's financial assets to the tune of maybe a couple of $100,000. That's a shame. And now this elderly parent whose health has further declined is not in a good position financially to take care of their own financial needs. And oftentimes a child or family member who might be absconding or stealing from their parent oftentimes may not be a person of good integrity and not have good character. And sadly, they're going to attract like-kind people like them, maybe a significant other, boyfriend, girlfriend, or whatever, who are going to see that, and they're going to want a piece of that as well. So really important, folks. How do you prevent that? Well, durable power of attorney. I talked about that recently in another educational video. You need to put that durable power of attorney in place when you're alive and well, maybe third quarter of life. So in the fourth quarter, if you become incapacitated, you already have your chosen person, the person you chose who you feel is most suitable, someone of good character, someone of strong integrity, someone who's going to do the right thing when no one else is watching, and they're going to watch your back. And they're going to make sure that your finances and your treasure chest are well protected. And they're going to manage those for your interest, for your benefit, to make sure you're well taken care of as you're journeying through the path of life. Maybe to pay for your medical bills and your medical care and things of that nature. So do not leave it up for someone to guess who that power of attorney should be, or the court to even pick that person for you, because they're busy and they don't always get it right if they pick a conservator, and that's going to be running up legal bills as well, because the court will often appoint court-appointed attorneys as well to make sure that they're also watching over you, and they are not free services. They are services that the court will charge and assess legal fees, and then you're paying those. Other things that your loved ones can do for you: review your mail, review your financial statements in your mail, but also your online access to your online accounts as well. So how can these situations be avoided? You have to or should pick someone. It doesn't have to be a family member, it could be your closest friend, and you could give them back a password to your financial accounts if you trust them unconditionally. Unconditional trust, okay? And from my experience, typically it's our client, Bill and Mary. Pick one of their children with not just financial acumen to manage their financial affairs for them, but also they have a strong trust, and that person has strong integrity and character as well, okay? Financial acumen, but also principles and integrity. And they're going to now be able to access not just your mail, they can open up your mail to see if there's any unusual withdrawals or purchases on your credit card statements, in your bank debit account statements and things of that nature, but also even more efficiently, they can log into your account and they can see if there's any withdrawals from your accounts or any payments made to organizations that may not look appropriate. So typically that is how these financial exploitation matters are discovered, looking at the paper trail, following the money trail, looking at the checkbook, looking at the bank statements, looking at the credit card statements and the debit card withdrawals, et cetera, et cetera. And that's usually takes the partnership of working with someone that you trust. And that person should be your durable power of attorney, or if you have a trust, it should also be your trustee or co-trustee. Pro tip here, typically working with clients recently, mother was the trustee of her own trust for several years. Now she's of age. Now she's in the fourth quarter of life. She came to our educational workshop. She came to the initial meetings with one of her children. My recommendation typically is to the client, now it's probably appropriate to name your trusted child as a co-trustee with you. So that allows them day one to help you manage your financial affairs, takes the burden off your shoulders. They are somewhat of a co-pilot to the plane, or co-pilot riding shotgun, driving the bus with you. Rather than having them in the back seat, they're driving with you. So if you need to take a break, you can delegate to them. The good news, you're still in charge. You have the power to hire and fire if you don't think they're doing a good job. Folks, thanks for joining us here today at elderlawcare.com. Strongly recommend pick up a copy of my book on Amazon, How to Avoid the Four-Headed Monster of Estate Planning in Elder Law, because I'll teach you how to slay that four-headed beast, which is probate court, the tax man, financial creditors and predators, and yes, maybe that $15,000 to $18,000 per month private pay nursing home. Folks, we have a duty to protect our seniors as they age in place. So whoever that person or persons may be in your lifetimes, take action, be their advocate, and advocate for them to protect them. Folks, thanks for joining us here today at elderlawcare.com.